Good afternoon, everyone. Thank you so much for being here. It is my great pleasure to welcome everybody here at this International Wrongful Conviction Day event. First time I'm holding this here at St. John's in person. We had one that we organized 2 years ago in 2020 virtually. It is great to actually have an audience to interact with, and so my name is Dr. Marina Sorochinski, and I'm a professor in the criminal justice program at the CCPS. I'm really happy to see you all here, and the reason why we're here, the Wrongful Conviction Day has been established by the Innocence Project in Canada back in 2014. So this is the 9th year that is being held and recognized. And this day is really to recognize, to inform, and to educate people about the issue of wrongful conviction, about the greatest injustice that we unfortunately face in our society today, both here in the US and internationally. The failure of the justice system to do justice, to do exactly what it is there to do. And so we are here to recognize the people who have been victimized by the system, their families and loved ones who also become the unfortunate victims of this issue. And it's a day for us to raise awareness and acknowledge this problem in order for us to be able to do something about it. So you may ask, you may wonder, what is the scope of the issue? How big is it really? This graph here is the most up-to-date that we have from the National Registry of Exonerations. It shows that we have currently, up-to-date, since 1989, exonerated a little bit over 3,000 people, 3,220 people that together lost 27,926 years of their lives, okay? And you may think, well, in the context of the whole country, well, that's not that much. But when we're looking at, this is now, remember, our focus of the event is locally zeroing in on New York, right? New York State alone is responsible for 10% of those exonerations, and of those, 42 have actually happened right here in Queens, okay? And again, you may think, well, okay, so in the context of everything that we have going on, is it that much? It is, by all means, just the tip of the iceberg, because by the most conservative estimates, about 3 to 5% of all convictions are wrongful in our system. And if we take that to look at how many people we actually have currently incarcerated, that's about 40 to 100,000 people being wrongfully incarcerated right now in the US. Okay, so it's quite substantial for us to think about and value the importance of being aware of this issue. So a little bit, a quick note of how this all fits within the university. There are a lot of things that we can do, right? As my personal goal as an educator is to raise awareness and help the younger generation of you guys, the incoming criminal justice administrators, legal professionals, lawyers, attorneys, to know what's happening to do your job better, right? We have recently established a project with the Jeffrey Deske Foundation that will a small step to helping reintegrate offenders, not offenders, I should say, wrongfully convicted individuals as they come out, to help them in certain ways in their lives. So, my forensic psychology students will have the pleasure of doing some of that work, and then hopefully we'll have a lot more that the university with us together can do as far as helping the cause. So just that's all for me, right? I don't want to take the floor. Really, I hope that you will be enlightened and moved and educated by the speakers today. But before I do so, Dr. Andrew Mackenzie, our Vice Provost.
Good afternoon.
Good afternoon.
Oh, I love this already. On behalf of our Provost and our Vice President for Academic Affairs, who's Dr. Simon Moeller, I extend a hearty St. John's welcome to each of you to this International Wrongful Conviction Day event, zeroing close to home wrongful convictions in Queens County. I'd like to thank the co-sponsors of the program, our Collins College of Professional Studies, the Deskovic Foundation, the Legal Aid Society, the Queens County District Attorney's Office, and our student-led Criminal Justice Association. To our distinguished panelists, thank you for your participation and for sharing your expertise and your knowledge and insights with us today. And a special thanks to Dr. Sorczynski for coordinating this afternoon's program and serving as panel moderator. You must have been in my head when I did my notes because I just stole your stuff. But I'm going to say it again. Yesterday, October 2nd, marked the 9th annual commemoration of International Wrongful Conviction Day. And according to the Wrongful Conviction Day website, since 1989, over 3,200 wrongful convictions have been revealed across the nation, with individuals collectively losing 27,200 years serving time for crimes they did not commit. And while the exact number of innocent people who remain in prison today is unknown, experts estimate that 2 to 5% of the nearly 2 million people in prison in the U.S. were wrongfully convicted, meaning that anywhere from 40,000 to 100,000 people are wrongly incarcerated at this very moment. The mission of St. John's University is built upon the teaching of St. Vincent de Paul and his belief in the dignity and worth of all persons, especially the poor and marginalized. In our mission statement here at the university, it states, "Wherever possible, we devote our intellectual and physical resources to search out the causes of poverty and social injustice and to encourage solutions that are adaptable, effective, and concrete." Through our Inside Out program, which some of you may be familiar with, since 2016, the university has brought its students into correctional facilities to take classes with incarcerated students. We have provided educational courses and workshops for incarcerated students at Rikers Island and the Queensboro Correctional Facility. This summer, the university entered a partnership with the Thrive for Life Prison Project and the Ignacio House of Studies. Thrive for Life creates opportunities for spiritual development and provides educational resources for incarcerated and formerly incarcerated individuals while partnering with local universities and local employers. So St. John's has agreed to partner with the organization to provide pathways to degree-bearing programs and scholarships for returning citizens who enroll here at St. John's. Other Thrive for Life educational partners include Columbia, NYU, and Mercy College. In closing, the mission of St. John's implores us to educate future criminal justice and legal professionals through a pedagogy based and rooted in social justice, to prepare those future professionals to provide a voice for those whose voices go unheard. We are proud to host such an important event here at St. John's, and we thank you all again for your participation. Thank you very much.
Thank you so much, Dr. Mackenzie. All right, now I will start with introducing our first speaker. Jeffrey Deskovic is an internationally recognized wrongful convictions expert and the founder of the Jeffrey Deskovic Foundation for Justice, which has freed to date 11 wrongfully convicted people and helped pass 3 laws aimed at preventing wrongful conviction. Jeff is also an advisory board member of the national coalition group It Could Happen to You, which helped pass 6 additional laws. He also serves on the Global Advisory Council of Restorative Justice International and co-owns the Recharge Beyond the Bars re-entry game. Jeff speaks across the country and internationally on wrongful conviction, criminal justice reform, and overcoming adversity. He regularly meets with the elected officials and makes frequent media appearances. Jeff's motivation is that he spent 16 years in prison from age 17 to 32 for a murder and rape that's based on a false confession, and I'm sure he will talk a little bit more about that himself. A documentary short about his advocacy and life after exoneration that's titled Conviction can be watched on Amazon Prime. Jeff's advocacy work in Queens specifically includes providing support to several Queens wrongful convictions cases that ended in exoneration under the prior Queens DA, writing about the pattern of prosecutorial misconduct in Queens under the prior DA, and writing op-eds. Jeff, along with co-counsel, are currently also seeking to exonerate several clients in the Queens cases. Now, I have a surprise for you, and I hope that you don't hate me for that. I know how you like things planned, everything, but before we have you speak, I have a little surprise for you. So today we have a special presentation for Jeff by H. Bosch Jr., president of Made to Believe LLC Network and Remash Media. Mr. Bosch is a radio and media personality, entrepreneur, speaker, and criminal justice reform advocate who also was wrongfully prosecuted. A true overcoming adversity specialist. So please welcome Mr. Bosch. He will
Thank you, Doctor, for that kind and gracious introduction. I drove 4 hours to get here, and as you can see, I had a bad hair day, but I'm not going to worry about that, all right? First, let me explain a little bit about Made to Believe LLC Network, because a lot of people work hard to put this together. We are a personal and professional development company which specializes in empowering people to overcome their adversities. So we didn't want to let another year go by without recognizing this great champion of criminal justice reform. So I'll say this, it gives me great honor and privilege to present to my good friend and fellow soldier on the field, on the battlefield, the Honorable Jeff Deskovich, with the first Made to Believe Jeff Deskovich Servant of Justice Overcoming Adversity Specialist Award. I just want to say real quick before he comes, everything I am and everything I hope to be in this movement is because of this man. So, go ahead.
all right. Jeff, and now it's all yours.
I can't stay long because I'm speaking at another event in Jersey, but I want to say God bless you to the crowd, everybody who showed up, and may heaven continue to smile upon you. And Doc, continue to let your light shine. You're doing a great, great, great job in this arena.
Thank you.
Surprise!
Yeah, really. Wow. Wow.
Thank you.
You leaving?
Get out. Wow. Give me a second. I did not see that coming at all.
That was the point of surprise.
This is true. This is true. This is true. Wow. Wow. So it's a tradition in Wrongful Conviction Day that we acknowledge people still fighting for freedom, as well as people who have finished the fight in terms of their own case. So I have some slides. Still carrying on that tradition, still fighting for freedom. Foundation client Andrew Krivak who did 23 years. His conviction's been overturned. He's home on bail, but he's on house arrest, ankle monitoring. He finally got a trial date set for a retrial. Same polygraphist who coerced the false confession out of me did the same thing to Andy. He made that claim way back when, before I was even a client of anyone, so he didn't come up with that claim after the fact. So I want to recognize him. And another foundation client, Mike DeLoe, who's waiting for a ruling. The judge has been sitting on his case for several years. He was wrongfully convicted on a child molestation case despite the DNA not matching him. We have John Brookins, who, nearly 30 years wrongfully incarcerated in Pennsylvania. The state is still fighting just to give him the DNA testing. So I want to recognize him as well. Now there's other people that are still fighting for freedom but who are not incarcerated, and so I want to acknowledge the people in the room. One of the foundation's clients is here, home after 27 years, still insisting on his innocence, still hoping to be exonerated. If you can stand and just give a brief wave, Mr. Ronaldo Clark. Also from Queens, a man that survived 40 years, who's also hoping to be exonerated. Greg Mingo is here with us. Another foundation client, not from, by the way, those two gentlemen were from Queens, not from Queens, but from Brooklyn, who did 25 years. The foundation helps him to get released on parole. John Whitfield is here. The case is still pending in the Brooklyn Conviction Review Unit. Home through clemency, but also hoping to obtain his exoneration, declare his name, from Manhattan. John Adrian Velasquez is here with us. And we have some Queens exonerees who are with us, who served 14 years in prison prior to exoneration. This was under the prior DA office. Kareem Bellamy is here. And also exonerated not that long ago, Robert Majors is here with us. Could you just briefly Okay, so today's wrongful conviction event, of course, we have the Queen's theme, and so just really quickly, we have slides to bring home who we're talking about. It's one thing to mention numbers; it's something else to put that flesh and blood. So I'm going to show slides of people who've been already exonerated in Queens. Prakash Churiman, who did 6 years, who was arrested when he was 15 prior to his conviction being overturned. Chad Breland, who did 24 years prior to exoneration. Gary Johnson did 24 years. Reuben Willis did 4 years. George Bell did 24 years. Rohan Bolt did 21 years. Roman Carlton did 31 years. Jathan Kendrick did 25 years. Mr. Kendrick recently passed away. Roberto Angeles Acosta did 24 years. One of our panelists who we'll hear more from later on, Felipe Rodriguez, did 29 years. Derek Red did 7 years. Lazaro Burks did 8 years. Angela Martinez did 16 years. Gerald Harris did 8 years. Lambert Charles did 5 years. Amin Alibaba did 3 years. And without photos, okay, we have Samuel Brownridge, who did 25 years. Julio Negron, who did 11 years. Rehan Taylor, who did 7 years. Shoaib O'Neal did 6 years. Jean Contave did 5 years. Raki Ramchair did 13. John Scott did 9. Clinton Turner did 17. Fancy Figueroa did 7. Shiwi Su did 11 years. Teddy Mustakas did 4. Terrence Mason did 8. Eddie Andre did 6. And Teobaldo Gucci, I probably butchered his name, did 5 years. So in terms of my own case, as was mentioned, I did 16 years, not in Queens. My case happened in Westchester County. I was arrested when I was 16 for a murder and rape, which I did not commit. This is my mugshot, by the way, when I was arrested, and my wrongful conviction was caused by a coerced false confession, prosecutorial misconduct, fraud by the medical examiner, terrible public defender. The prosecutorial misconduct that happened in my case was that, well, firstly, one day before officially getting the negative DNA test results, the prosecutor rushed to the grand jury to indict me before he officially received the results, so he didn't have to present that evidence. At trial, when the DNA had excluded me, he came up with an argument. He theorized that, well, first he got the medical examiner to alter his testimony. So 6 months after doing the autopsy, once the DNA didn't match me, the medical examiner suddenly remembered that he forgot. You got that right? He remembered that he forgot to document medical evidence that he claimed showed that the victim had been promiscuous, and that's what allowed the prosecutor to overcome the DNA. Aha! That's how the DNA doesn't match Deskovic, and yet he was still guilty. He went so far as to mention another youth by name that he claimed had slept with the victim, but that was misconduct because he never set the proper evidentiary foundation for that. So he never, for example, got a DNA sample from this other youth to do the testing. He never even called him as a witness. He simply made the unsupported argument to the jury. The medical examiner, who, by the way, had altered his findings in 3 other cases, it was always this prosecutor, the medical examiner, doing this. He had been complained in neighboring counties by law enforcement, where he was moonlighting as a defense expert. So whichever way the money flowed was how he oriented his testimony. So none of those complaints were ever turned over to my defense lawyer. So we never had that information to work with. I did lose 7 appeals. I got turned down for parole. So this is a picture of me in the courtroom when I was given the 15 to life sentence. By this point, I was 17 years old. This is a picture in the courtroom. I kind of reversed the order, but it was announced that the jury had reached a verdict, but prior to it having been read. Here's a picture of me when I, shortly after I arrived in Elmira Correctional Facility, a men's maximum security prison. Sent there, of course, because I had been charged and tried and sentenced as an adult, and therefore I was sent to a men's maximum security prison. I was exonerated through further DNA testing vis-a-vis the DNA database, which not only affirmed the prior result, but it also identified the actual perpetrator. So here's when I was released. Hugging my mother for the first time outside of a prison setting in 16 years. Next photo depicts the difficulty in trying to put your life back together again. So the after effects range from psychological to the stigmatic aspect of it. You were in prison for 16 years wrongfully, but you were there for 16 years, so how much of that rubbed off on you. From family, immediate and extended, and being awkward when I would meet up with them, since I had not had any contact with nearly any of them, and the few I did, it was sporadic, to technological, GPS, cell phone, internet hadn't been created, culture being different, neighborhoods looking different, being released with nothing, being very lonely. I lost all of my friends when I had been arrested. One of them came to see me one time, and one person maintained contact for 5 years before we lost touch. So for most intents and purposes, I did the time on myself. But coming back directly to the point that I'm trying to make right now is it was very lonely. I was released with nothing, as all exonerees are. I did file for compensation, but that's a legal process. It took 5 years. So all those factors kind of converging at once are encapsulated by the photo. So I'm just going to zip through a few other pictures. This opening my foundation, which was referenced before by Dr. Sorochinsky. Our first person we helped exonerate was William Lopez, who did 23.5 years. Bill passed away after a year and a half of being framed. William Hawley, who did 8 years and 4 months on my left with a red tie. Arson case that was actually an electrical fire. The DA agreed that he was completely innocent. Bill passed away not that long ago as well. What we're talking about today, and you'll hear from the panelists, it's not an anti-law enforcement, but we definitely are against cops that are engaged in misconduct, coerce false confessions, withhold Brady material, facilitate misidentifications, test a lie, otherwise run over state and federal constitutional rights. Definitely against them, definitely against prosecutors doing the same. But with respect to people in those professions that are doing their job in an ethical and legal manner, no issues at all. This photo kind of illustrates that. The buy-in I've gotten from law enforcement. This picture was taken when I spoke at the Police Academy in New Jersey. I've done that twice a year for the last 8 years. Getting my master's degree from John Jay College, getting the law degree in 2019. We referenced the coalition group, It Could Happen to You, so here I got an award in connection with the landmark legislation we passed, assisted by many of the people here that have been welcomed and otherwise in the audience, the Commission on Prosecutor Conduct. Next thing I wanted to briefly speak about, just in terms of my, legislation that we have passed. There was the Commission on Prosecutor Conduct, so independent oversight board for prosecutors, which would have the ability to investigate prosecutorial misconduct. So there was that. Then discovery reform. So discovery means sharing information by both sides. So previously, under the old law, prosecutors were only required to turn over prior witness statements from witnesses that they were planning to call, either pre-trial or trial, or at the trial they would not have to turn anything else over. They had to turn over exculpatory material under the Brady, but there was nothing really to enforce all of these Brady violations, and hence the need for the Commission on Prosecutor Conduct. And in terms of discovery, often witness statements would be dumped on a defense lawyer's desk on the eve of the hearing, on the eve of a trial. So getting the discovery reform passed was important. The DNA database expansion was another piece of legislation. I was exonerated through the data bank, so upon conviction, I'm personally in favor of the data bank being enlarged so that there's more of a chance in those cases with DNA of finding the actual perpetrator, which of course simultaneously exonerates people. Better identification procedures, videotaping interrogations, so that was passed, but that did come out as Swiss cheese. They made exceptions for homicide, sex offenses, and drug cases, and really those are the cases where we need it the most. Pennsylvania, exonerees were in a peculiar situation of being exonerated in court, but still having a record. So it was really, you had to hire a lawyer and go through a lot of legal, jump through a lot of hoops, which many people frankly couldn't. And so when it came to being hired for jobs or renting apartments or in other contexts, you would have exonerees arguing that they're exonerated and showing newspaper articles, and would-be employers and other decision makers pointing to their rap sheet and the rap sheet winning out. So we were able to pass that. So that's my, well, in terms of advocacy here in Queens, as was mentioned, there were a couple of cases in Queens, like the foundation wrote a letter in support of Robert Majors when he went to the parole board, and some grassroots tactics, just attending court proceedings, hoping to pack the courtroom and inviting media. Often in a wrongful conviction case, many elements are working together. It is the police and prosecutors, perhaps experts, sometimes judges, hence the sarcastic term, the second prosecutor in the room, and sometimes defense lawyers also, and even the media. So my point in mentioning that is that It's very seldom, if ever, that an exoneration is pulled off by one person or one entity. It's many people working together, playing many different roles. I did the same thing on an unsuccessful case, the Haji Jones case in Queens. I did with the new administration. It is a breath of fresh air. I've spoken several times with Mr. Benjet, the head of the Conviction Review Unit. I spoke several times with him in front of the Queens DA office on a few different wrongful conviction topics, and so that's kind of a breath of fresh air. In terms, that would have never happened under a prior administration, and people have been exonerated under the unit, but I'll let him discuss that part of it. I have written about wrongful conviction cases here in Queens. One of the articles I referenced that in the She We Sue case, that Attorney Joel Rudin, in his civil rights lawsuit that he successfully filed on behalf of Mr. Sue, which resulted in $3.5 million being paid. He had documented that there were 80 reversals based on prosecutorial misconduct right here in Queens. And I remember writing also on the John Taylor case, where he was the last Mr. Taylor was the last death penalty case on the books. The court had invalidated capital punishment in New York, and so that last death penalty case, had that been decided a different way, that could have caused capital punishment to come back in New York. And the prior DA had this bizarre position that while he personally was opposed to the death penalty, his case was appealing a prior ruling which invalidated the death penalty, which could have resulted in it being brought back. So, maybe that might not technically be prosecutorial misconduct, but it's certainly immoral, given the obvious risk of executing somebody innocent. Two of the cases we're working on, I referenced Ronaldo Clark and Naran Dozier as well. They both have, Mr. Dozier has a case pending in the Queens Conviction Review Unit, and we're still waiting for records on Mr. Clark, but we're being assisted in terms of that. So that's my presentation. You'll hear just a peep out of me. At the end, I'll discuss some of the pending legislation right now in the legislature, which could prevent wrongful convictions. But for now, I'm going to thank you all for my attention and your attention, rather, and I hope I wasn't too long-winded. I suspect I probably was.
Thank you so much, Jeff, and I think you are being a bit too humble. Everything that you are doing in this innocence movement that we are all hopefully part of. So our next speaker is Mr. Eric Turner, who is an exoneree from the Queens County, and he's going to speak a little bit about his case.
How you doing?
Hi.
Good.
How you doing?
That's Eric with a K on the end of it.
Oh,
This is the K.
what? Yeah.
But my name is Eric Turner. I'm from Jamaica, Queens, New York. I was arrested and wrongfully convicted of criminal possession of a weapon. I received 3.5 years, 2 years post-release supervisions, and just to speak on the reintegration after that into society, the community, it's just a struggle. I know it's an everyday struggle for a normal person getting released from prison to come home and try to get back into the community and what's going on, family, just get back to their normal life. And it's a hard process. Jobs are not hiring sometimes. You got a lot of different things going on and a lot of factors determining whether you would feed your family or not. The specific reason I was exonerated was because an officer planted a weapon on me, but he was found to have done a whole bunch of other things to other people as well, like lying on the jury, on the stand, planting evidence and everything. I'm just here to bring a little light to it, like to what's going on out there, like what's really going on out here. Every cop is not bad, I believe that, but there's some people out here that's doing some messed up things, and I just feel like they need to be held accountable for it. That's it.
Thank you, Eric, and I apologize for.
It's all right.
Right. Our next speaker is Christine Ballum. She's an attorney with the Wrongful Conviction Unit of the Legal Aid Society. Christine has worked for the Legal Aid Society for over 25 years in all three of its practice areas: civil, juvenile, and criminal, representing New Yorkers in individual and law reform matters. She is a recipient of the Legal Aid Society's Charles Shinsky Award for outstanding service. She's also a co-founder of Preparing Leaders of Tomorrow Inc., a Brooklyn-based mentoring program. Christine received a bachelor's degree from Purdue University and her Juris Doctor from St. John's University, so an alumna of ours.
Thank you. Talk about pandering, right? I had to add that to my bio. And I'm a very proud alum of the class of '96 here. So thank you, and thank you, Eric, Felipe, gentlemen here in the front row, throughout the audience, people that are watching from wherever. These are the people that are the experts in the field, the exonerees, the wrongfully convicted. These are the people that lead the work. These are the people that tell the truth, and we need them to continue telling the truth. These are the people that speak truth to power. They're making the impossible possible. They are bringing hope to those that are left behind. They're bringing hope to those of us working in this field to keep fighting. And we owe them a huge debt of gratitude. And did I not say Jeffrey when I said Felipe and Eric? I skipped over Jeffrey. So thank you all, and I just want to acknowledge you and your presence and your hard work. That never ends. So, a little bit about the Legal Aid Society and the Wrongful Conviction Unit. Today I'm going to talk about who we are, what some of the challenges we face are, some of the successes in our short history, and I want to end with opportunities for you all to get involved and help in this important work. So who we are. Legal Aid Society Wrongful Conviction Unit was created just in 2019, so we're very new. The Legal Aid Society in general has been around since the 1800s, so we're the largest and oldest provider of legal services in the country. However, our Wrongful Conviction Unit is really brand new. We started with one lawyer, one investigator, and one paralegal, and in the last 2 years we've grown to 4 lawyers, 3 amazing paralegals, and an investigator. We have a partnership with CUNY Law School Clinic, the Defender Clinic there, and we're able to harness assistance and resources from CUNY. We have a relationship with Henry Lee Institute up in New Haven. They're working with the CUNY Clinic to provide expertise and forensics expertise in particular to our cases. And we have the benefit of other law students, volunteers, anyone that has an interest and can come to us and to devote some of their skills and resources. This unit was created specifically for people who have exhausted all appeals and who continue to fight for their freedom and to clear their names. So our clients come from the 5 boroughs, so we, although we get letters from people all over the state, we are limited in terms of our resources to representing those people who have had convictions in one of the 5 boroughs. Again, they've exhausted appeals and they have a claim of actual innocence. We're working now on any somewhere upwards of 20 cases. We're in all 5 boroughs, as I mentioned, and we have a wait list of over 150 people that we're hoping to help. So, what we do. Our work involves intensive investigations, and I'm sure you'll hear from Mr. Benjet about that work as well. Both our offices engage in very intensive investigations. Our cases are typically not DNA dispositive cases, meaning that it's the guilt or innocence of a person will not rest on one particular forensic test result. Those cases are few and far between at this stage, and so they're incredibly fact-intensive, labor-intensive, and time-intensive. We look for witnesses who may have never been spoken to. We try to discover new evidence. We go back over the case and talk to the people who were involved at the inception of the case, at the inception of the investigation. We confront witnesses who have given false testimony. We look to uncover official misconduct, whether it be through testimony or through documents and records. We go back from the beginning. Now, our cases originate, now we have cases that we've been working on from the 70s, okay? So some from the 80s, many from the 90s, and even a few post-millennial, I guess, 2000. But these cases, when I tell you they're old, they're very old, and the investigations are very challenging. And what do? We are working very closely with our clients, again, the experts, those who have been fighting, often from the inside, who know their cases better than anyone, who know the details, the records, have foiled. We'll talk a little bit about FOIL in a minute. They've engaged in Freedom of Information Law requests just for years trying to gather the information they need from the inside. So we work with our clients, and we're client-centered in our approach, and we develop legal theories and claims, again, not just one, but as many that are applicable, and we present to the district attorney offices, so there's at least a unit in each borough, or perhaps a person or two devoted to conviction review or post-conviction review in each of the 5 boroughs. So we develop an extensive memoranda, and we enlist the CRUs to work with us. We reach out to them, we present to them, we ask them to join us in the investigation. Another pathway or route might be to file directly in court as criminal procedure law motion, a 440 motion, and that's the vehicle used to both accomplish exoneration through the courts and also to recover evidence for testing, for forensic testing. So we go into court and file those motions. So challenges, I'm sure I've kind of emphasized some of them along the way, right? So challenges are the time that has passed, that has elapsed since the conviction, the resources, the lack of resources. Well, one of the challenges that continues to come up in most of our cases is really confronting and acknowledging systemic racism, okay? Living and having grown up here in New York, acknowledging that racism had a role in many, not all, but many of these convictions. And so I'm going to also refer you back to the National Registry on Exonerations. They have a website. They have extensive data on exonerations, on the causes, and the people who have been exonerated. But they also have released a report just this month called Race and Wrongful Convictions in the U.S. 2022, and they have some data that is really stark. Just going to read just an excerpt from the report. Black people are 13.6% of the American population, but 53% of the 3,200 exonerations listed in the National Register of Exonerations. So judging from this data, innocent Black Americans are 7 times more likely than white Americans to be falsely convicted of serious crimes. So I encourage you to look at that report and to look at the data. The report also reveals that racial disparity in varying degrees cuts across all major crime categories with the exception of white-collar crime. So we see this in very serious cases where people are serving excessively long sentences, including murder and rape. We see this routinely in our offices. and we also see it in drug crimes. So challenges. I'm not done, fortunately. We need help. We need labor. We need people to help us to uncover misconduct, to look for witnesses, to scour through evidence, to organize volumes and volumes of data, of documents, of transcripts. We also have the benefit of, at times, working with experts. So we can benefit from assistance of undergraduate students, law students, people who might think they have nothing to offer. There may be something for you in this work. I want to just touch briefly about how we get our cases. Some cases do come by referral from lawyers, but the overwhelming majority of our cases come directly from those impacted. They write to us. We receive letters on a daily basis from people explaining in heart-wrenching detail what they've been through and how they're facing incarceration for something they didn't commit, and how they've been turned away from just about every other organization. So there are very few resources available to people in this position, and certainly there are very few organizations that can provide the assistance at no cost. Again, because this is so labor intensive, we find that the work can be incredibly costly, and private counsel can be out of reach for most, if not all, incarcerated people. So, successes. I want to touch on some of our work. We have had one exoneration. We're very, our unit has not been in existence for terribly long. We've had an exoneration out of Kings County. We have several cases pending before conviction review units in each of the 5 boroughs now, so we're working in each of the boroughs, including Staten Island. We have Mr. Mingo's case pending here in Queens. We're working very hard for all of our clients across the city. We've been successful in parole advocacy, and that's a conversation for another day, but how does one go before the parole board to express remorse for something they didn't do? How do they show they've been rehabilitated when they didn't do the crime? And they're met with skepticism, perhaps even cynicism. And we've had some great success more recently. We feel the board, at certain configurations of the board, are more open to this. So we're writing extensive parole advocacy memos and packets to submit that reiterate what this person has been saying all along, that they are innocent, that there is legitimacy to their claim, that their claims are under investigation and perhaps even pending with the conviction review unit. So we've seen success in bringing some of those people home, and then we continue to fight for their freedom from lifetime parole or their freedom to clear their name. So we ask you to join in our successes. How can you help? Max Powell is here in the second row with me. Max is a paralegal at the Legal Aid Society's Wrongful Conviction Unit, and he and I will stick around. But we do have a pro bono unit at the Legal Aid Society that recruits volunteers. We also have a very active recruitment office, so undergraduate students can get involved in investigative work, law students can get involved in investigative or legal work. Again, people who don't have, who aren't students can get involved. We have a pretty active docket of volunteers that we keep very busy. So thank you all for being here today, and thank you for all the good work you're doing, gentlemen.
Thank you so much for the wonderful work that you're doing. And again, students, if you're considering options of, if you're planning on going into the legal area, but even if you're not, something to help you sleep better at night, feel like your life is not wasted, help out on some of that work, and it comes a long way. And hopefully also, this is a kind of a hint, right? I hope that we can establish something a little bit more also permanent down the line with St. John's in terms of a clinic or a collaborative work with the Jeffrey Deskery Foundation and help bring in students to do the legwork, to do some help with more cases than obviously a lot of the non-profit associations and foundations and our offices are just out of hands to work through those cases, the thousands of people behind bars that are hoping to get some help. This is where it can be made real. So our next speaker today is another exoneree from the Queens County, also an ex-auxiliary officer of the police at the time of his wrongful conviction. So please welcome Mr. Felipe Rodriguez.
Good afternoon.
Good afternoon.
I want to thank Adrian, Mr. Clark, Mr. Lingette, down here, Eric, and all the exonerees and the people that have been wrongfully convicted at some point or another. I arrived in the United States in the late 70s, not on my own accord. My mother thought it was great to come from Puerto Rico to the United States and look for the American dream, as everybody wants. They believe that you come to America and everything is sweet and roses and beautiful. Unfortunately for me, I started on the right path. I became an auxiliary police officer in 1982. I was going to go to aviation school to become a pilot for the air support unit for the NYPD. That was what I wanted to do. Unfortunately, there was two Irish detectives that didn't think that SPICS was allowed in the NYPD. They didn't think I belonged there. So they started messing with me at some point during 1988. They came to me and they said, look, if you help us out, you got a brand new baby, married, you can go and live your life. I said, how do you want me to help you out? They put a statement in front of me saying that I knew this guy committed this murder and that he told me what happened, and I said, I can't sign that. I said, I'm not doing that. I said, I don't know anything about that. He said, either one of you two spaces is going to go down for it, so you choose. I'm giving you a chance. Either you go home to your family, or I'll get the other guy to flip on you. You go to jail. I said, go ahead, do whatever you want. And I was young, and I wasn't afraid of the cops because I was already wearing a uniform. So his intimidation didn't really touch me. So I told him a few words that I won't repeat here. I don't think it was pretty wise, but I did win and told him where to go. So he said, all right. So I went home. He said, go home. For the next 6 months, I thought it was over. I didn't think nothing of it. I went to the precinct at the A3 to work, and they were waiting for me there. It was like a movie type of thing when you got a nice reception, a whole bunch of guys in suits, and they told me to come with me, and I went with them, and they said that I had borrowed the car. First, they accused me of murder in the second degree. It was a brutal murder. It was vicious. It was like 38 stab wounds. They said that I borrowed the car, I returned the car full of blood, and that I had told some guy at a bar that I was a plumber, and that the guy had a conversation with me. So I looked at the cops and I said, you guys must be on drugs. He said, how do you plan to do this, dude? I mean, I have nothing to do with this. He said, I told you. So it happened like the doctor said, and like the legal aid societies just mentioned. Lawyers are very costly. A lot of us are wrongfully convicted, end up wrongfully convicted because we don't have proper representation. You need a good lawyer in order for you to defend yourself against an adversarial system that is a monster. The DA's office, and no offense intended to Mr. Benjet, but the DA back in the days, in the 80s and middle 90s, was a big animal, and they had all the resources. So most of us didn't have no resources. Most of us had either 18B or a legal aid lawyer. And those legal lawyers back then had 20 cases. So how much work do you think they could do for you and me? No experts. Private investigators are the cheapest private investigator they can find, and guys have probably never been in Boy Scouts. So how do you think they're going to investigate anything for us? So it turned out that my lawyer was an 18B, may she rest in peace. My lawyer, when she took my case, she was dealing with some demons. Her son was loan sharking with the mob. So she was so occupied with trying to keep her son alive that she started stealing money from the Bar Association when she was the president of the Lawyers Bar Association. So she stole about $240,000 just to pay her son's debts. And her husband was sick, so she had time for my case. So I was failed at every end. The DA's office didn't protect me, my lawyer didn't protect me, the cops didn't protect me. So I was public enemy number one against everybody. So at the end of 2 weeks, maybe a week and a half trial, I was found guilty of murder in the 2nd degree, possession of weapon in the 4th degree. They didn't find the weapons, but they got to charge you with a weapon because they assumed that the person was killed with a weapon. The evidence was flawed. The car, according to the DA's office, I committed the crime in the car. They went and stripped the car up, but they didn't find one drop of blood. How do you stop somebody 38 times inside of a vehicle and don't find one drop of blood? I think even CSI couldn't clean that car. Never mind. Then they went and they went as far as bringing a guy that pointed a finger at me in the courtroom and said, "Oh yeah, he was at the bar with the deceased, and I seen him and we had a conversation." But this guy was on probation at the time. He testified in the stand that on the night that he so famously recalls that he seen me, he had smoked 5 joints of marijuana, smoked a pint of vodka and orange juice, and then when he got to the bar, he had several double rum and cokes. I don't know what he was watching, but at that point, I don't think he was watching anything. That didn't even occur. But anyway, so this was the people's case, pretty much. And they had the guy they wanted me to accuse, they had him turn around and sign the same statement that I wouldn't sign against him. He signed it against me. He wasn't as strong as I was. So I guess Jeffrey's is prime witness, I'm sure a lot of us, when the police puts pressure on you, some people just cave. Some people just, and some cops really beat you. Some cops really put the pressure on you. So I guess he couldn't stand it. So I was sentenced on May 2nd, 1990 to 25 years to life. I immediately started writing letters to everybody and their mother that I thought that I could write. Brooklyn Law School, second program, John Jay, I wrote Oprah Winfrey, I wrote Peter Jennings, Tom Brokaw, I wrote Alan Dershowitz. When I tell you I wrote letters, I wrote maybe about 500 letters. I wrote Barry Shack and Peter Neufeld because I had followed the O.J. Simpson's case, and I thought that that was the best people that could get me out, and ultimately they were the ones who got me out. So dreams do come true. You just gotta wish hard enough. I was watching the '95 trial of O.J. Simpson. I was at Wendy Correctional Facility. I watched the whole trial, and I said, "Wow, I need these guys. I want to get these guys, and I'm going to get out." I did just that, and then I started going back and forth with the letters. Hillary Clinton and Bill Clinton wrote me back and sent me to the Innocence Project. Peter Jennings sent me to the Innocence Project. Alan Dershowitz sent me to the Innocence Project. So when I sent all my letters that they have gotten from these people to the Innocence Project, Barry Shack said, either you are really an innocent guy or you're an idiot. He said, wow. He said, I want to see the letters that you have, that you're saying that you sent. So I sent him all the letters. He came to see me, we sat down, we had a few laughs, and he said, hang tight. And that's when everything began. Then the Innocence Project got the brilliant idea that I couldn't stay in prison and I needed to get out. So Nina Morrison, who's the Honorable Judge Nina Morrison now for the Eastern District, who I am so grateful to, I owe her my life practically. She decided to come and visit me and say, I want to try to get you a pardon commutation, and I want to go to the governor. And I said, nah. I said, I don't want no. I'm ready to die in prison. It's either I'm exonerated or I don't want to leave like this. So Nina's a great lawyer. That's why she's a judge now. She talked me into. She said, look, I got some real marvelous tickets for the Yankees. She said, you and your son can go watch the Yankees. She said, it's legend tickets. You let me do this, you go, I get you out, you go watch the game with your son, and I'll keep fighting to exonerate you. So I said, all right, go ahead, give it a shot. So Yankee tickets got me out. So she went and pitched it to the governor. The governor visited me and asked me a few questions, and he said, sit tight. 2 weeks later, I was the first prisoner in New York State with an A1 felony murder to get a commutation. And I understand it. The backlash is great. If I would have came out and I would have been a serial killer, and what would he say? So I know he had to think hard, and he went and looked at all the evidence. Nina Morrison and Zachariah Marbuli-Zanuma pitched a great case to the governor. He got me out. Then a week later, he invited me to the Rockefeller House for a party that he threw. I went there, and he introduced me to James O'Neill. He was the police commissioner then in 2017. And the governor told the commissioner, you know this guy? So the commissioner looked at me and said, yeah, I seen him on TV. He said, no, you know who he is? I said, no. He said, this is for you, brother? He said, oh, yeah, I already know. So the governor said, I don't know what you guys did. I don't want to know. I said, but this stinks. Get it right. Straighten it out. The governor didn't have to do that. About 2 weeks later, I had the entire NYPD file. Well, not me, my lawyers. So it was fantastic. My journey began. Then on December 30th, 2019, I was finally exonerated by the Queens District Attorney's Office. Robert Masters, on his way out, of course, that was his last day, so he decided to go out with a bang. He admitted that the Brady violations were egregious and that they could have had a different effect if I would have had all that material on my trial. However, he didn't want to concede that I was innocent. So, you know, he did exonerate me, but he kind of gave me a knee, you know. Would it have been different if police misconduct would not taking place in my case and the DA's office would have acted differently? Yeah, I believe so. So the police misconduct, the prosecutorial misconduct, and my deficiency of receiving legal assistance was the biggest part of me spending 27 years and 9 months in prison. Something that should never happened. My son was only 2 years old. Now he's a grown man. I don't know my son. I'm trying to. You just can't come into somebody's life after 27 years and 9 months and say, well, I'm your dad, now I'm gonna rule your world. I don't think it works that way, so. Unfortunately, this is something that we need to do. We need to pair up with Jeffrey Deskovic, his foundation, with the Legal Aid Society, and all of us, exonerees and the guys that are trying to get exonerated. We need to get together and we need to change the system, for sure.
Amen.
There is no doubt about the need to change the criminal justice system. We need to hold DAs accountable. We need to hold cops accountable. We need to hold legislators accountable. We need to push these people and let them know this is not right. You can't continue doing this. My life, they stole my life. I got compensation. I only got state compensation. The city, I still got a lawsuit against the city. So, but there's not enough money in the Treasury Department to pay me for the 27 years and 9 months they stole from me, or for the damage they've caused to my son, my mother, my father. So I encourage you. I hope that you guys really get interested into this and get your hands and dive into this and let's change our criminal justice system. Thank you for your time.
Thank you. Thank you so much, Felipe. And it is true, and what I always keep telling my students is my personal kind of sense of what we can do at this point is change the system from the bottom up. You guys who are getting into the criminal justice administration and the legal work and the future attorneys and prosecutors, once you know this, you've heard this, you cannot unknow it. So it's on you, it's your responsibility to become better professionals, to do the job, to actually change the system by not going along with the way that it currently is, okay? And with that said, in the years that I have been organizing events about wrongful convictions, and it's been years, I've started doing this since I was a student myself back at John Jay. We've been doing a variety of events on wrongful convictions, on different aspects of it. I have never, ever had a guest who is on the other side of the system, okay, from the DA's office itself, okay? But Mr. Bryce Benjett, who is the director of the Queens County District Attorney's Conviction Integrity Unit, actually infiltrated the system from the other side himself, right? So before joining the Queens County's DA's office in January of 2020, Mr. Benjett was a senior staff attorney with the Innocence Project and a clinical professor at Cardozo University School of Law, focusing on forensic evidence. His work at the Innocence Project resulted in the exoneration of 10 innocent men and women in the jurisdiction around the country.
First of all, I want to thank Drs. McKenzie and Sorochinski for inviting me and for sponsoring this event. You know, it's great to have a day to mark the problems of wrongful conviction. As a you know, member of the government, often when we speak, we have to have disclaimers. And so just in an abundance of caution, I want to say that the Queens County District Attorney's Office and in my respect as an invited guest, and sort of my comments are mine, and comments of the speakers are the comments of the speakers. I also want to just say that, you know, my comments today are not about specific cases, and I always try to be careful when speaking to a room where there are folks in front of us, and so that's a limitation that I want to put out. And again, on behalf of District Attorney Melinda Katz, I want to thank everybody in the room for coming and for marking this day. And I also want to thank some of my staff that have come here, and they're really sort of much along the lines with the legal aid, the kind of the front line in looking at these cases, and we could not dig through the many cases that come into our office without their diligent work. So what I want to talk a little bit today is just how the District Attorney's Office and our Conviction Integrity Unit looks at cases, what our process is, what sort of the preliminary results in the 2.5 years that we've been in existence, and talk a little bit about what we've seen and what we can learn from the work in New York City. So just to begin with, this is nothing new. Prosecutors have had a duty forever to look at these cases. Now, traditionally prosecutors see once we get a conviction, it's our, you know, we need to stand by these convictions. But it's always been true that we don't need to stand by convictions that are not just. It sounds silly, but when you get embedded into an adversarial system, you very much buy into that system. And so traditionally prosecutors would say, my job is to defend, legal aid's job is to you know, bring these cases, and let's leave it to the judge to make a decision. And there's a certain logic to that, but it ignores the duty of prosecutors to do justice. And so we need to examine cases even when there's been a conviction to make sure that conviction is accurate and was obtained fairly. And so that's what we do. Now, conviction integrity units, or conviction review units, so you can call it what you will, is taking this principle and creating an actual procedure, a system by which we can do that effectively. And why is that? And that's because when you look at the actual system that the criminal justice system is in place today, it's not very effective in sorting through claims of innocence and adjudicating those. When you look at how a person, and we have folks here, finds themselves in prison and they claim that they're innocent, what can they do to prove it? You're locked in a prison cell. Your Sixth Amendment right to a counsel at trial no longer applies once you're convicted. So you don't have a right to counsel. You don't have a right to information. You may have rights to discovery pre-trial, but you don't have that right to discovery. You can't compel the government to give you information once you're incarcerated. And so just logistically, it is virtually impossible to reinvestigate your case once you're convicted and incarcerated. And once you have information that you believe might prove your innocence, there are all kinds of barriers for you to actually get that into court. There are time limitations to get into federal court. You have a year from when you discover that evidence to get that into court. You have procedural limitations. If you filed, and you'll talk to exonerees, they filed, 5, 10, 20, there's an exoneree, Jabbar Collins, who I think filed over 70 lawsuits before he was able to get the information that proved his innocence. Each time you file one of those appeals, you're creating a barrier for a subsequent appeal. And so there are all kinds of limitations for you to get that evidence into court. And then there's what we call deference. Once a judge decides something, courts tend to go along with that. And so you see these cases where there are appeal after appeal after appeal. There's an appearance of real review, but the system is set up in such a way that it's more tends to be about procedure than the facts. And so what conviction review programs, what our conviction integrity unit focuses on is what happened, not whether there's some procedural issue at play, but what are the actual facts. Because at the end of the day, here in Queens, throughout the country, thousands and thousands of criminal cases have been adjudicated. And you would just be, we're not so arrogant to think that we get it right every time. And so we've talked about error rates, and I'm not sure there's a good way to find out what that error rate is, but I think everybody can agree that there is an error rate. And when you're multiplying that by thousands and thousands of cases, there are going to be mistakes that were made. So what are the scope of what we do at the Conviction Integrity Unit? The bread and butter of what we do are the cases that we're here about, that we're talking about, which are cases that go to guilt or innocence. We will look at essentially every case where somebody is coming to us and saying that they're not guilty. Because we are tasked with looking at cases, our earliest case in review is from the 70s. And so when you're looking at virtually 50 years of cases, we do have priorities and some prioritization of folks who are currently incarcerated, but that's not a hard and fast rule. And I don't want to underestimate how difficult that is, even from the position of a prosecutor. We do have the advantage of access to information. I assume that when I call the NYPD, they pick up the phone a little quicker than my colleague at Legal Aid. But at the end of the day, trying to track down witnesses from 30 years ago is not an easy task. And so this is painstaking work that requires a lot of manpower. We have excellent detectives that work with us every day, and they're out knocking on doors. But it's difficult and time-consuming work. So that's one aspect of the practice. We also look at sort of more systemic issues, and that's going to be a theme of really what we do. Whether it's misconduct by police officers or by prosecutors, where there is a problem with a part of the system that we look at, we focus on that. So for example, our office was presented when we started with evidence that one of our prosecutors many years ago in the 90s was discriminating on the basis of race, gender, and national origin in jury selection. Now those cases generally do not go to the factual guilt or innocence of the person convicted, but certainly goes to the confidence in the process. And frankly, it's evidence of discrimination against those people who that ADA determined were not fit to serve. And so that was something that we felt very strongly that we needed to remedy. And so we conducted an audit of all of the cases tried by that assistant district attorney, and then in fact actually did an audit of cases tried by the bureaus that he was in. And so far, we've reversed 4 cases where we've found evidence of racial discrimination in the jury selection, and we're continuing to review other convictions, but we wanted to do those immediately because those defendants were actually suffering immediate consequences from those convictions. So that's an example of kind of a misconduct type review, which doesn't necessarily go to guilt or innocence, but I think is very important in confirming public confidence in what our office does. And then finally, unreliable evidence. We haven't done one of these types of reviews yet in Queens County, but you'll hear this about arson evidence. I think Jeff talked about an arson case. Sort of there's famous instances where people were identified by their bite marks. Sort of vast categories of evidence that we now know is unreliable, and examining that kind of evidence and doing an audit that way. And so those are sort of the individual and the systemic approaches that DA's offices will conduct these kind of reviews. And so our process, and this really goes to the individual guilt innocence investigations, really has 3 components that are different from, again, what we talked about before, where it's, let's fight it out and the judge will decide. So first of all, we're independent. Our conviction integrity unit, and really it's a best practice, I think, should be independent of the chain of command within a prosecutor's office. If you are working under the bureau chief that authorized the prosecution in the first place, there's going to be institutional pressure for you not to necessarily create problems with that conviction. And so our unit reports directly to District Attorney Katz, and that's important both for the independence of our judgments, the appearance of the independence of our judgments. I certainly, if I look at a case and do not think that there was a problem with the conviction, I don't want the public thinking, well, I'm doing that to protect some member of our office. And so that independence, I think, is crucial for both the way for this to work correctly and for the public to perceive that it's working correctly. And then the second 2 are really related, that these are non-adversarial investigations. Again, if you're relying on the adversarial system, that places the burden on the convicted person to produce the evidence when they don't have the resources or the tools necessary to discover that evidence. And so we do not do these investigations while cases are pending in court. We really, in many ways we look at ourselves as kind of a safety valve. So most of the cases that we are investigating are cases that have been rejected previously, although not necessarily all of them. Again, the question is not, are there procedural issues? What does the law say? The real question is, as a matter of fact, what happened? And if what happened was a miscarriage of justice, the law tends to accommodate those situations once you have the facts. So it's really a factual investigation first to determine what happened, and then we go from there. And then finally, it's collaborative. And again, this is a system of human beings, and so not every investigation, not every situation is perfectly situated for this, but we draw on each other's strengths. Certainly, as I said before, we have access to information at the DA's office. I can call up a police officer and find out what they know. I can go get records that may not be available publicly. But if I got to interview the convicted person who says they're innocent's nephew about some uncomfortable thing that happened, sending a couple of retired NYPD detectives to that person's door is not going to be very effective. And so there are many times where we look at who's going to do that job better, and we draw on the strengths of each partner in these investigations. Again, with the objective not to win a case or to defend a case, but to find out what happened, what are the facts. And again, our system of justice and our system of laws, imperfect as it is, when you have compelling facts, the law tends to accommodate. So what does our CIU look like here in Queens? We have had over 200 cases submitted to us in the last, I guess we're going on 3 years now. And we can keep a docket of about 20 active investigations going at a time, which I think is similar to what Legal Aid handles. And that's not to say that every single investigation is hot at every moment, but the idea is really to identify cases on the front end where there are credible claims. And so sorting through those 200 cases, are there cases with credible claims of innocence and that are provable? And those are the ones that we open investigations on. Since we started in 2020, we've had 7 reversals and dismissals in cases where the facts went to questions of guilt or innocence. There are various legal standards, and New York, at least in our appellate department, has a very, very high standard for what the court has termed a claim of actual innocence. So which doesn't even involve questions of reasonable doubt. It's affirmative proof of innocence. And so those are very difficult burdens to meet. But 7 cases that we've resolved with regard to questions of guilt or innocence, the 4 Batson cases that I've mentioned, and then we are also conducting a kind of a more systemic review of cases by officers who have been convicted of perjury or other misconduct in their police work. And so that's an ongoing project, but we've done 60 reversals and dismissals as part of that program. And then, in some ways as important, we've rejected about 30 cases at some place in the process. And in many ways, that's important too, to recognize that not everybody who's writing to us is actually innocent, and to get some finality in that process. I don't think it behooves anybody to leave people on a list just for the purpose of leaving people on a list. So much of the idea behind this work is obviously to get to the facts, to right wrongs, to free innocent people. But as important in many ways is to learn from this process. And one of the ideas behind conviction integrity units really stems from ideas in other industries. We see this in hospitals, we see this in other industries, and this is sort of the classic Innocence Project analogy that, if a 737 falls from the sky and crashes, we don't just clean up the plane and keep flying it. There is a process in place where you examine what went wrong. You bring in engineers, you bring in safety experts, you figure out what's wrong with that airplane, and you fix it before you feel good about flying that thing again. If there's an error in a hospital, the hospital doesn't just sort of like pay the victim the medical malpractice recovery and then keep doing the same thing. They have a process in place to look what happened, what went wrong, what can we do to fix that. And that's a principle that unfortunately has been slow to the criminal justice system. But it's something that we try to be informed with. Some of the most important examples that I see in New York is the discovery reforms. In so many cases, we see perfectly legal practices of late discovery or independent disclosures that were blessed by courts for decades, that created a risk of wrongful conviction. And now with discovery laws that require timely disclosure of much broader types of information, that addresses that risk. On a more micro level, we had a case in which a fingerprint report had matched another person to a crime scene several years after the conviction. And that report was sent to the precinct and was never acted upon and was not discovered for many, many years. Just seeing that small issue come up, we made arrangements with the NYPD latent print lab, which at the time was not an accredited lab. Now it's accredited. It has scientific standards that apply to what they're doing. And they will give us any cold hits now. And so when you see a problem, the attitude is, how can we fix this? How can we prevent these things from happening again? And so looking at New York City convictions, and much of this is based on an excellent report that was done on the first 25 wrongful convictions recognized in Brooklyn. False confessions is a key aspect. Our understanding of how people respond to aggressive questioning has certainly evolved over the decades, and that's a key aspect. People get put in a room, and frankly, if you have a crime committed by a street gang and no real witnesses, there's not a lot of good ways to solve that other than to question people. But what we now know is the tactics that were commonly used created risks of false confessions, and so now we have to sort through those. Eyewitness misidentifications. People are not videotape machines, and we now know a lot about the risk of false identifications. False statements by witnesses, that's another leading factor in New York City, very akin to the false confessions. Same types of practices that could create a risk of a person falsely accusing themselves of a crime could easily result in somebody falsely accusing another. And then finally, failures by members of the system. And this comes to basic failures to review documents, interview witnesses, people making mistakes, people not doing your job, or affirmative misconduct. And so those are really the key aspects that we see that create wrongful convictions in New York City generally. And when you look at the cases that have been reversed under the Conviction Integrity Unit, that pretty much lines up. And so again, the idea behind all of this is that the adversarial system, the legal system that we have in court, does not do a good job of identifying and remedying claims of innocence. And so we have to take it out of that system. We have to deal with these cases separately because it's just too important to ignore. So I appreciate all of your time, and again, the university for sponsoring this.
Thank you so much. So just before I open up the floor for questions, Jeffrey wanted to give a little sum up of what are the future, what do we need to do, what's coming up?
Sure. Before I get to that, just a few people walked in the room that were not here during the initial part. We recognized, people who've been exonerated or who are en route to exoneration. So I want to briefly recognize those people. Prakash Shiraman, whose slide we showed earlier, is with us here. If you want to stand and just wave. Fighting for exoneration with his case in the Queens Conviction Integrity Unit. Henry Smith, home after 25 years. And I want to to recognize falsely accused but not convicted Anthony Dolce is also with us. You could stand for a brief second. So in terms of what's coming up now, so as I mentioned earlier, in 2018 we did pass the Commission on Prosecutor Conduct. And myself and my colleagues, we met with the governor's team, and she put $1,750,000 into the state budget to fund the commission, because without any funding, the commission is just a paper tiger. So that's done. The last leg is we're waiting for the Assembly Minority Leader and the Senate Minority Leader to make their picks. So we didn't want to have a commission where any one individual or any one political party could stack the deck. So we split the picks, in the legislation. So, the governor got picks, the Chief Justice of the Court of Appeals got picks, the Assembly, Speaker of the Assembly got picks, the Minority Leader in the Assembly got picks, the President of the Senate has picks, and the Minority Leader in the Senate has picks. So the issue right now is that the Assembly Minority Leader and the Minority Leader on the Senate have not made their picks, and so the commission is still, as of yet, not up and running. Myself and advocates, we're working on that. So if you're out there listening, whether in audience or the secondary audience live, we definitely need emails, faxes, phone calls to the Senate Minority Leader and the Assembly Minority Leader. We need you to make your picks, and we need the governor to actually announce her picks, because they're said to have been made, but nobody knows who's been selected. So that's in terms of the commission. There's a few bills which I'll quickly go through. So one of them is the Challenging Wrongful Convictions Act, and that's a bill which has the following key elements to it. You've heard different speakers discuss organizations being overwhelmed by the sheer number of applications. You've heard people talk about writing many letters. I wrote letters for 4 years looking to find free representation, which is because there is no right to an attorney in a post-conviction proceeding. So the Challenging Wrongful Convictions Act has a provision in it in which defendants would have a right to an attorney in a post-conviction proceeding. So that's a key element of the Challenging Wrongful Convictions Act. And another thing is that bad case law on the books, in the case People versus Tiger, Court of Appeals said that once you've pled guilty, and we know that innocent people do plead guilty, it's been estimated, there was a judge who estimated 10%. Although, just like talking about the wrongful conviction error rate, you really can't know, because you can only add the exonerations, and if you could count the other cases, then the conviction still wouldn't be intact. But nonetheless, my point is innocent people plead guilty. And if you've pled guilty, let's say you had a terrible attorney and you were given the option, you could plead guilty to charge with murder, you're facing a 25-year life, or you could plead guilty and get 5 to 15. And a lot of people plead guilty in a damage control, pragmatic type of decision. Well, let's say that was facilitated by a terrible attorney who rarely came to see you, who did no investigation, who had way too large a caseload, and you understand exactly what's going on, and you know that you're going down, basically. So you take the plea. Now you get competent counsel subsequent to that, and a good investigator, and previously unknown evidence of innocence is discovered. Your attorney would not be allowed to argue in a post-conviction motion that you're actually innocent. You could not make a newly discovered evidence claim. You would be relegated to simply arguing that this evidence demonstrates that there was inadequate investigation. So I have a case like that in Erie County. My client, Omar Clark, I'm co-counsel on, and we've gotten a ton of evidence that his lawyers never uncovered, never did any investigation, and we're jumping through these contortions in the courtroom and in the filings, and we're not really able to make the best argument, which is the actual innocence argument and the newly discovered evidence argument. So that bill would correct that. And lastly, anything that previously was criminalized but has now become legal, it would give defendants the right to go to court and remove those crimes from their record, which you would think would It should go without saying, except that it doesn't. So that's the Challenging Wrongful Convictions Act. So we definitely need people to, again, contact your senator, your assembly person, and express support for that. Last year we had the bill. It was passed by the Assembly, and the Senate would not give us a general floor vote. We got all the way to the end, and they wouldn't put the legislation on the floor. And we had the votes, so we're at it again, and we need to continue to show public support for that. There's recognizing that false confessions have led to wrongful convictions in 25% of the DNA-proven wrongful convictions. There's several bills that would address that. There's the Youth Interrogation Act, which has a proposal in it that it recognizes that people 16 and 17 years old are not able to understand their warnings when they're given the Miranda warnings. Anything you say can and will be done against you in a court of law. I remember reflecting on myself when my rights would be read to me, and every time I got to that provision where it would be used against you in a court of law, my mind went to the civil court. And I would think, court, what are you talking about? We're not going to court, not understanding. And that experience is common. So the Youth Interrogation Act would require defendants 16 and 17, suspects 16 and 17 years old, they would have to consult with counsel to explain their rights prior to their being able to then waive them. That's an initiative being headed up by the Bronx Legal Aid, so an example of policy work that Christina referenced, and I've been working with them on that issue. There's another bill referred to as a police deception bill, which recognizes that police officers lying to suspects is inherently coercive, and so it would ban deception. Lastly, we don't have a bill yet, but we've been working with elected officials, and the bill will come out soon, I believe. I mentioned that in 2017 that we were able to pass a law that required police to videotape interrogations from beginning to end, that being one of the best practices intended to curtail false confessions. And to be clear, if somebody is being threatened, do they really have guilty knowledge, or are they being given facts that they then regurgitate back out? But the bill came out Swiss cheese, and as I mentioned earlier, they made exceptions for homicides, sex offenses, and drug cases, which is the types of cases that we really need it the most. So we're trying to clean up those exceptions. So we need verbal support, and otherwise, please let your elected officials know you're in favor of that. False charges. That it's not only law enforcement. Sometimes for a wide variety of motivations. Sometimes civilians hurl false accusations against other civilians. And so I want to briefly ask Anthony Dolce to come for a second and to discuss a little bit about that bill. His group, Stop False Police Reporting, is spearheading efforts at passing a provision that would address that. So I'm going to ask him to come really briefly and share just a little bit about your story and how that relates to the legislation you're trying to pass.
Thank you. Thank you everyone for being here. My name is Anthony Dolce. I'm the director and co-founder of the Stop False Police Reporting Group and the co-author of the Stop False Police Reporting Initiative. My wrongful arrest involves landlord-tenant harassment by my former landlord. I was facing 1 year in prison for a crime I didn't commit after my former Manhattan landlord, Dorchester Towers, had instructed their employees to call the police on my family if we spend more than 2 minutes in the hallway or the lobby of our own building while we were residents. In total, the employees of this building called the police on my family 31 times, and when they called the police, they made false allegations about my husband and I, threatened to kill the staff and harassing the staff, and made allegations that I was mentally unstable. Their false reporting caused me to go to jail and spend 9 days in a psychiatric ward, wrongfully committed to a psychiatric ward where I didn't belong. And in total, I was placed in handcuffs 10 times because of their false allegations. And this is one of the main reasons why I got involved with false police reporting by law enforcement and civilian. Our group meets every week giving support to other individuals like myself, a place where they can share their feelings and what they went through and what they suffered. And we are also working on the Stop False Police Reporting Initiative, which contains 6 provisions to combat false reporting by law enforcement and civilians. Provision number 1 and 2 will make it a felony for both civilians and law enforcement officers who file false police reports against a person of a protected class. Provision number 3 is transparency. We want defendants who are maintaining their innocence to have the right to know why their case was dismissed. I discovered in Manhattan on the district attorney's website that over 50,000 cases are dismissed every year. And we don't know how many of these are due to false reporting. So provision number 3 will make it mandatory for the prosecutor to seek the truth on both sides. And when a case is dismissed, the prosecutor must put in writing what led to that decision. Number 4 is police accountability for both pre and post conviction. Provision number 5 deals with immigration, and provision number 6, data management. When someone is found guilty of filing a false police report, both law enforcement and civilians will be placed on this registry to track and record who is committing this crime, so we can weed out the civilians and the bad apple police officers who are using the criminal justice system as a weapon against innocent people's lives. So one of the best ways you can help is to help volunteer with our group. We go out on the street every week gathering petitions for our initiative. You can follow us on Facebook at Stop False Police Reporting. You can also find our petition on change.org, Stop False Police Reporting. My name is Anthony Dolce, and we're the Stop False Police Reporting group. Thank you.
Thank you so much. So we are almost out of time, but I do want to open up the floor for questions to any of our speakers, and thank you again, all of our speakers, for being here. So we questions. Yes.
Yes, does this integrity unit that you have in Queens only exist to Queens County, or does it exist to other counties?
Yeah, we only have jurisdiction in Queens County. All 5 boroughs, the DA's offices do have, 4 have, I think, dedicated units. I think Staten Island has a program. So all of the New York City offices have an avenue for this, but the Queens County only looks at Queens County convictions.
Yes.
I would like to know how many reported cases by law enforcement and civilians, how many convictions there's been so far this year in Queens District?
Oh, gosh, I don't know the answer to that. I do believe that there are, statistics released annually that, because I know I've looked at county numbers of adjudications, and in part just to get a base rate, when you're thinking about, whatever the error rate is, there have been hundreds and, going on millions of cases adjudicated in New York City over the last 50 years, and so that gives you an idea of what the potential for error is.
Thank you.
Yeah.
Let's have one more question. But what if, what if the complaint is against a lab technician coming out of your county.
I think we can discuss specific issues maybe after the event. I'm sure the speakers will be happy to stay for a few minutes.
What do you mean? What do you mean by a lab technician?
I think he's saying if it's a case in a different borough, but the lab person happens to have been from Queens, the lab was Queens. That's that your question?
Yes.
So in that case, the jurisdiction still belongs in the county in which the the jurisdiction is in the borough where the case happened. It would not suddenly, the Queens DA's office would not have jurisdiction over that issue.
Questions? Yes.
Hi, thank you guys so much for being here. I'd like to know if the CIU addresses any issues with civil commitment. And then I know that the CJA in Manhattan, Criminal Justice Academy in Manhattan, are looking at some of the structured clinical assessments that we have, like the static 99 and the VRAD, other things that are using these static and dynamic risk factors like number of arrests in the previous stage, like first stage of arrest, but we know that these are based on biases because if the community is over policed, then of course somebody will have more arrests or somebody will be younger with arrests. Are you guys aware? Are you guys familiar? Are you thinking about this at all for either of these things? People reach out to you civil.
So I guess civil, we have not had any submissions of, cases involving a claim of a wrongful civil commitment. And, I've not looked into that. I'd be happy to listen about it if there are issues there. And I'm not aware of these. I've seen it in other jurisdictions with regard to bail decisions, some of these algorithms and processes like that. But I'm not aware that they're being used in Queens.
Other questions? So let me ask you, and maybe everybody can have some thoughts on this. But most of you speakers have alluded to the issues of the system and kind of the adversarial system, the DAs and the police officers kind of coming at it with the idea of getting a conviction. How do we change the culture?
I think forums like this are a step. I think the existence of a real conviction review unit as opposed to one not existing at all, or as opposed to a window dressing type of unit like used to go on in Manhattan. I think that's part of it. Just even in terms of collectively reinvestigating a case. I mean, I've worked with Bryce on a few cases the foundation's doing, and I don't perceive that that's adversarial. We're working in partnership, so I think that's part of it. And I think just trying to bring the members of the other district attorneys, it would be wonderful if one district attorney or another, tried to proliferate the idea of conviction review units amongst peers and, up and down New York and as well as across the country. Brooklyn DA Thompson did that once, and then he passed away, but nobody has done that since. And I think that's part of it.
I also think, to expand on what you said, I also think that it's important that people understand that this is very real. That a lot of people are not educated as to, wrongful convictions or police misconduct or prosecutorial misconduct or, the mishaps of a person finding themselves incarcerated until he touches them. If I didn't go to prison, my family would have never really looked into, does it really, is there any police misconduct out there? They would have never even given it a second look. And most people don't take a look at this until it affects them personally, into their son, their nephew, their daughter, their husband, find themselves in a prison cell or in handcuffs. So to change the culture, we have to take time and educate everybody else that wants to get involved with this, because I don't think Bryce can change this on his own. I mean, this is a collective effort, and we all got to come together, and we got to work with them. We got to work with law enforcement. We got to work with our DAs, and we got to understand, like you said, they're human. You know, we got the error factor here. So, but we must to change the culture. We must interact with our law enforcement. We have to.
I think there's a role also, you know, with the passage of wrongful conviction prevention intended legislation. I think that's part of it, and I think electing the right people of either political party that's running on a justice reform, wrongful conviction prevention and correction platform is really important.
Can I say something real quick? I'm gonna piggyback over what you said just now, because I was thinking the same thing. It's a mindset thing. If we look at exonerations as a whole and change the mindset of it, oh, he's just in prison, automatic bad guy. If we lose that thought process, then we can even be open to the thought process of there are people in prison that are not supposed to be there.
Absolutely. I just want to add also, just quickly, that, you know, elections matter, and so our local district attorneys are elected officials. And so it is a new day in Queens, and many of us who have lived in Queens or have you know, been residents of New York City, many of the DAs that were here, they were institutions. And so they worked lockstep with NYPD. There wasn't, you know, any sort of scrutiny necessarily or accountability. I mean, I'm talking largely, I'm sure there were individuals along the way that tried to do the right thing, but so there was this, and it goes again tied with systemic racism and the lack of getting involved in local politics, people just sort of like, you know, being marginalized and not having access to being heard. And so, you know, I think elections matter, and I think now we're seeing DAs come in, we're seeing legislators being voted in that are taking on these systemic issues. And it's very encouraging, but there's a tremendous backlash now. So I don't know if you're reading the papers or watching the news. I mean, it's a difficult time in New York, and so we don't want to see some of these gains lost. You know, these are important gains, and they matter.
So with that said, actually, Mr. Rice, you mentioned that your unit is kind of independent of the rest of the prosecutorial office. How are the relationships there? Like, how does the main kind of prosecutorial office take the fact that there's now a unit that looks back at their cases?
Well, I think, you know, as one good example, I mean, we've been able to bring Jeff in, and we gave an office-wide lecture on the problems of false confessions. And we've also trained the incoming classes, I think at least once. And so just again, that's a voice that I think is important for our members of our staff to hear. And I think that, you know, any institution, and ultimately the district attorney's office in Queens is a government office consisting of a staff of roughly 800 people. And so, you know, this is an institution that works 24 hours a day, 7 days a week, 365 days a year, devoted to keeping us safe and acknowledging that the people in that office, that's what they're trying to do. And you know, as much credit as we give to them, we cannot look at the problems of wrongful conviction as sort of this duality of you're either a bad actor or you get it right every single time. The issue is really, how do we, as judges, as lawyers, on the defense side, as prosecutors, work together to raise the standard of care. And you know, because there are bad actors, but when you look at these things from the perspective of there's a bad apple in the barrel, you ignore the fact that this is a human process that is doing incredibly important work that has huge consequences, both protecting the community and has the potential to harm people in ways that we really cannot remedy. And how do we learn from our mistakes? How do we create systems that protect people in a better way. But that is a generational change that I think everybody's struggling with.
I think we need to start holding public servants accountable. That's what needs to happen.
I honestly, I feel like they hold public, like, servants kind of too high for the standards. Because honestly, you have public servants like police officers that come from like Westchester County, Long Island. They come to New York and they don't understand how New York runs, how a New Yorker looks. So they have their mindset of how their community is. They come here and police it, and they don't understand who's actually somebody's running for a bus or somebody that's actually done something. Sometimes you just literally just come and they like racial profiling or like just profiling somebody's face. Because I know certain police officers, they have that mindset like, oh, okay, once somebody's convicted or even somebody's got in trouble once, he's a the perpetrator. That's all they be saying. I have family members, police officers have done that. So it's like sometimes it's like it's a whole mind state of like, you know, that's what we have to break out. The police mind state, also sometimes the DA office where it's the relationship where, okay, you know what, I need to get this off fast, so I want to go home. So can you do this? And sometimes it happens. So I think honestly it's on the broader spectrum where somebody's able to like govern their own people, it should be able to be better because people understand each other from a community. But if you go out selling to another community, you're not gonna understand that. That's why.
Thank you. We just have another
Yeah.
question.
So mainly question for the attorneys here, but the others could definitely answer. So my basic question is, so in my class for criminal psychological assessment, we discussed how even some experts that are testifying at these trials don't even have like any real credentials, but they're still able to testify and make a very bad decision. So how do we fix that within the system, and how do you, the attorneys, how do you, let's say, go against on cross, if you have to, how do you go against that, and how do you try to discredit them?
I mean, I'll just start, and then two experts on either side of me can speak to it. I mean, just having done trial work, you know, when you have pre-trial hearings, confined hearings, there are opportunities before things are presented before the jury to really challenge that, right? So that's something that you would absolutely do, but you have to then become an expert yourself. So often we would consult with an expert to evaluate an expert report and essentially challenge that person's either their credentials or whatever their process was that led to their, conclusion or opinion. And so, I think in New York we've gotten better. I hear in other parts of the country really incredible, incredulous things that are accepted as fact and truth in the courtroom that might not make it here. So that's something I think that we can feel good about. But yes, I mean, as science emerges, though now we're looking at artificial intelligence, we're looking at facial recognition, we're looking at, even DNA, right, and transfer. There's stuff that has not yet been settled, and as defense counsel, as attorneys, we're going to be, there's going to be a new battleground in some of these areas. So I think it's a very good question.
Yeah, I just want to. But I mean, you can have, integrity units review cases that were based on that, and as a defense attorney or a nonprofit trying to exonerate people, you're certainly challenging evidence that was previously admitted. That's the way of doing it. But then also, as science has evolved, the decade or several decades, what was once passed for evidence is now recognized as not. So when that happens, you can use this, and this is where like the tie-in to research and scientific validity can be applied in the courtroom, like when the National Academy of Sciences, released a report that detailed a lot of types of evidence that used to be allowed in the courtroom but is recognized as not being valid. I mean, things like tire tracks, footprints, hair comparison, even fingerprints where there's not a consensus on how many points of match there have to be in order to be considered match, bite mark testimony. So all that was recognized as not being scientific. Why was it not? Because there were no underlying scientific studies in order to know what the error rate actually was. So with that report, you could challenge convictions on that. Some states have. California, the governor just signed into law a bill which would explicitly give defendants a right to challenge a conviction if it was obtained in part through that evidence. So I think those types of bills are another way of doing it.
Thank you. So I think we're out of time officially, at least, but I do want to thank again wholeheartedly our from who have actually been personally affected by wrongful convictions. I really appreciate you being here and taking the time to come, and thank you for thank you to St. John's for supporting, continuously supporting our efforts to do something in the in contributing to the innocence movement. Now. We do have some food outside that people can enjoy, and also have maybe some questions to the speakers that you wanted to talk about.